to enforce this Constitution. And I like to tell folks I'm a textualist or an originalist. I believe the Constitution was written by our original framers for a reason, and I believe that what it said, it says what it means what it says, and that's when I'm looking at a constitutional issue, that's what I'm looking at. I'm also the consistent conservative in the race. I believe the court should stay in our lane. We should not be an activist court. We should not try to legislate from the bench. I believe that I have shown in my opinions that I've been consistently conservative, whether I was writing opinions that were protecting parental rights, the fundamental right of a parent to make a health care decision for their child, whether it was about health care or mass mandates, my decisions always were conservative and held that the government could not mandate the personal health care decision of an individual. I also have stood up for gun rights, protected our Second Amendment. We also had a speedy trial case. Y'all may not have heard about that case. It came out of East Arkansas. I know a little bit about speedy trial because I went behind Dan Harmon, and we had over 4,000 felony cases that were over 2 years old when I got there, and we looked at speedy trial on every case, and my goal was to save every case I could. I counted the days, and I made sure if there were ways to, because for one thing, the rule that the Supreme Court uses is not in the Constitution. They have this rule, it's kind of a crazy rule, that you count so many days, and there's so many excludable periods, and all this, but that's not what the Constitution says. The Constitution just says that there's a right to a speedy trial. And if you look at the court case, the U.S. Supreme Court, U.S. Supreme Court has said you should be very careful when you're looking at speedy trial issues, especially in light of the need to hold these people accountable. So I'm probably not quoting it properly. Tim can tell you what it really says, but we had a case. It was a cop killer case. A guy. It was a retaliatory cop killer. The defendant literally drove by the police officer's house that had arrested him with a gun, shot through his front window in the presence of his young children. Could have killed the children as well. Shot and killed him. The case went to trial, and yes, it took a while over in East Arkansas to get it to trial, and this was pre-COVID. And the circuit judge determined that speedy trial was not violated, and so did the prosecutor's office. The only person contending that speedy trial had been violated was a defense attorney who actually was later lost his license because he was not truthful, and also so anyway. That being said, Justice Womack and I both wrote a dissent in that the majority found speedy trial, notwithstanding what the court had held, that speedy trial had been violated, and let the guy out of prison after he got a life sentence for this murder. And I'm sure the folks over there weren't very happy with it, because the prosecutor told me after the fact that they did get the federal system to go ahead and lock him back up for a couple of years, but that's the best they can do. But I don't think we should have a court that's looking for ways to let people out of prison when the jury says they should go to prison, especially when it's an obvious decision like that. The other case I wrote the majority in, which I'm sure you're familiar with, is the Learns case. I was honored that it was assigned to me, and I was able to get the majority to agree with me, and it basically was a constitutional issue. Did the legislature follow the Constitution? And if you read the decision, you'll see that we felt like it was a very straightforward case. The Constitution says when the legislature votes on an emergency clause, they vote twice. And if they put it in the record of the legislature that they voted twice, that's the evidence. And that's what you look at. And there was actually an Arkansas Supreme Court from the 1918 that said that. And we just wrote the decision based on what the Constitution said, because in this case, the legislature recorded two separate votes, one on the main bill, one on the emergency clause. And we felt like it was important to write that opinion because even though the time for emergency clause was gone and some argued it was moot, that is the way the legislature had passed all of these laws for the last 2 decades. And we knew we were going to get inundated by litigation for some laws that somebody might not like, contending that, well, I think I can prove they only took 1 vote, not 2 votes. But a lot of that stuff you read in the media was not what was in evidence. What was in evidence was they took 2 votes. So, but that's what you have to have, is someone who's willing to look at the evidence and look at the law and apply it, as I said, as written. And I'm going to say, finally, talk about experience. As Jennifer said, I've tried cases for over 40 years. I like to tell people I started when I was 5. You women understand that, right? Okay. I was on the bench for 20 years as an administrative law judge and as a circuit judge here in Saline County, and then, of course, on the Supreme Court. And I think the thing that really distinguishes me in this race from my opponents, in addition to being the consistent conservative, is that I'm the only one in the race that has managed a state agency. And the reason that's important, that is the role of the Chief Justice. We have an administrative agency called the Administrative Office of the Courts with over 100 employees that provide services not just to the Supreme Court and the Court of Appeals, but to every circuit judge, every district court, every specialty court, and they're there to provide security, to provide technology, to provide all kinds of resources so these courts function on time and they don't get backlogged, although we did in COVID. But that's the goal of this the CEO of a state agency, is to work with the legislature to make sure if there's a problem, the legislature addresses it. Not to be the legislature, but to address it. And also to manage the budgets and personnel. And as Chief Justice, I will do that. And as I said, I've got a proven record, and the only one that's had hands-on management experience as the CEO of a state agency. Some people have asked me, well, what does the Chief Justice do? And how does that work? So I'm going to give you a little background on that. And then the Chief Justice is, as I said, the Chief Judge. There's 7 justices on the court. The Chief Justice in Arkansas is elected by all the people of the state of Arkansas, just like the other justices. And the Chief Justice serves basically as an equal justice on the court with the other 6 justices. The only thing is the Chief Justice takes on additional supervisory roles for, as I mentioned, the administrative office of the courts, those employees, as well as if there's something that comes up that the court has to have it, like, relates to the Bar Association, and the Chief Justice is the designated representative to talk to the Bar Association on official business, as well as to set a vision plan and a plan for the courts, where the courts are going over the next few years, as well as if there's a need for a special judge. If a judge has to recuse from a case, the Chief Justice works with that. We have several committees that the court has, whether it's disciplinary committee for attorneys and judges, or whether it's some of the other committees. I think the access to justice, there's a committee the Chief Justice oversees which justice gets appointed to those committees. And as I tell people, as a new judge on the court, I can look at things with fresh eyes, and I can see things that historically aren't working. And one of the things that currently happens in the court is that the senior justices won't let the new justices serve on any of the committees. So you get the same thing over and over, and you get the same problems over and over, and you don't get resolutions to those problems. So I think that's something that, as a Chief Justice, I would look at seeing what could be changed about that. So I'm kind of it's an 8-year term. So if I'm elected, I would be serving for the next 8 years as the Chief Justice. I'm currently in an 8-year term, and I'm halfway through. So if I don't get elected, I'll still have 4 more years on the court. But that's true of the other 2 justices just got elected to 8-year terms, so they'll remain on the court as well. It's made for some interesting conversations at the court. And they have their reasons for running as well, that I believe I bring, like as I said, the things to the table that we need in Arkansas. I guess at this point I can open it for questions. Is there anything anybody wants to ask?